Hi, Mr. Montgomery.
Hi.
Can you place yourself on mute until the judge calls your case, please?
What? Please do what?
Can you place yourself on mute?
Mute. Sure.
Thank you. Hi, the person on the phone, what case are you here for?
Hello?
Good afternoon. Welcome to courtroom C307. Please ensure that your name and case number appear on the screen. If they do not, click on participants at the bottom of the screen, then click on your name, then click on more, and then rename yourself with your name and case number. Please mute your microphone on the lower left-hand corner of your screen until your case is called. If there is any background noise or chatter from other participants, it will disrupt the proceedings. None of these proceedings are to be recorded unless you're a court reporter. If any of these proceedings are recorded, you may be subject to an order of contempt. We are all new to appearing in court via the computer, so let's all be patient with each other. You are appearing in court right now, only it's through a computer, so act as if you are actually in the courtroom and conduct yourselves and dress accordingly. When your case is called, raise your hand so that I can see it on the screen. At the end of your court proceeding today, I will designate one of the parties to prepare the order. In the order, please state exactly which parties were present and whether they were represented by counsel. You will then submit the order via email to cc307@lakecountyil.gov. Hang on just a moment, please. Again, that's cc307@lakecountyil.gov. That's where you're going to email the order to. Please submit it no later than 3 o'clock today if possible. In any event, no later than close of business today. Please check the chat function at the bottom of the page frequently. The clerk may need necessary information from you. You can only chat with the clerk privately. You cannot send the judge a private chat. That would be an inappropriate ex parte communication. Also, do not chat with everyone in the virtual courtroom. Stay off of the chat function unless you need to contact the clerk with necessary information about your case. Do not overload the clerk with unnecessary chat questions. Ensure that your chat only goes to the clerk and not everyone. When you click on chat, the default setting is everyone. You need to click off of that, find the clerk, and then send her a private message, okay? Otherwise, it goes to everyone, which we do not want. iPhone users, if you get a message from chat, click on it immediately or else it'll disappear. If you accidentally get kicked out of the hearing due to operator error, please go to the 19th Judicial website and rejoin immediately. If your case gets set for a future trial date, make sure you're prepared for the trial. Have any photos or documents downloaded to your computer so that you can show them on the share screen function in Zoom. You should practice this before the actual trial date. If anyone wishes to say something at the trial, they need to be in the Zoom hearing for the trial. I cannot read a letter from someone. If you're here on a collection matter and you're claiming an exemption or wish to return at a later date with an attorney, please tell me that as soon as you appear in front of me when your case is called. The exemptions are listed on the citation you were mailed or served with. Once your case has been called and your matter has been concluded, please leave the meeting by clicking on the red button on the lower left or right-hand corner of the screen so that we can narrow down the cases that remain. Again, we will get to everyone as soon as we can, and thank you for your patience. All right, let's see. Are there any agreed orders? Oh. That one I'm going to save for the end. Board of Managers versus Lamping. You can unmute yourself.
Good afternoon, Your Honor. Sandra on behalf of the plaintiff.
Yes. Is anyone else here on that case? All right. What are we up for?
This is our initial return date. We have service on the defendant and unknown occupants through substitute service.
All right. Is this subsidized housing?
No, it is not. It's a condominium association.
All right. Just a moment. All right, just a moment, please. Okay, so you need to have a covered dwelling affidavit,
Oh, that's right.
right? And that's, hang on, that's, I can give you the site if you need it.
I'll write it down. I think I have printed it at the office, but I would certainly appreciate the site.
It's Illinois Supreme Court Order, MR 30370, and it's dated May 22nd of 20. There's several orders that are dated that are have the case number MR 30370, so you have to go by date.
Okay,
This
thank you.
date, this one's dated 5/22 of 20. And they have a form covered dwelling affidavit that connected to that order that you can use.
I did print it. I just didn't remember to use it for today's court
No
appearance.
problem. So we need that. Then we need notice that we need the Zoom notice so that the defendant knows to appear by Zoom.
I did mail him a letter last week with the instructions.
That had the Zoom notice on it,
I copied the whole notice that was in the,
administrative
Website.
order.
Mhm.
Well, that's not in the file. You
No,
should
I can e-file.
that because it's your burden to prove that you gave them adequate Zoom notice. So you need to file that, okay?
along with the affidavit, should be e-filed or should be sent to the, pardon me, the other email address for the orders. Just regular e-file those two?
Yes, you're gonna e-file those,
Fine.
okay? Just like you would anything else. All right, then, so why don't we continue this for a short date? And then, you can show that, the person has an opportunity to appear by Zoom. Because the courtroom's locked. They might be outside the door right now trying to get in for their court date. And they're like, what's going on? So,
I did talk to him on Monday,
wow.
and so he knew that there was availability of Zoom, but I don't know of his capability by phone or by
Okay.
computer.
But like I said, it's your burden to show that. So, you said you mailed them the letter, so you should e-file that, okay?
I will do that,
All right.
certainly.
All right, so let's
I
do
think-
pardon me?
I'm sorry. I'm not, this is my first time doing a Zoom, so I apologize for over speaking to your voice.
No, it's, believe me, it takes some getting used to, trust me.
And I think we e-filed our process server e-filed the returns of service.
I saw that.
Good, thank you.
That's in there. All right, now, because the Zoom is slowing everything down, we're capping our court dates. So we can't have 80 cases in the morning and 80 in the afternoon like we used to.
I understand.
Okay? So hang on. We can come back. How does that Monday afternoon look, Madam Clerk, July 13th?
26.
I can put, the soonest I can get you in is Monday afternoon, July 13th.
That's fine.
Okay. So we'll do a continuance order for then, okay? You can do that. Along with the Zoom notice for the new date. Okay?
I'm sorry, the Zoom notice.
You have to let the defendant know that we're doing court to appear in court by Zoom.
Okay, so
So
send him another,
when you send him the order with the new date on it, in the envelope or however you're gonna do it, right? You have to also put in the Zoom notice. Okay?
certainly.
Now, you may have to adjust the language a bit because in the AO, it says on the date listed below, right, do not come to court. There's not going to be a date listed below. So you may need to adjust it and say on the date in the attached order or something like that. You got to, right? All right. Okay, anything else?
1:30. No, I think that's good. I hope I have all the email addresses. I'll do the 2 e-filings
Well, you file it just like you would anything else.
for David and the letter, original letter. I'm sorry?
You would file it just like you do anything else, your complaint or whatever, okay?
Will do.
Okay.
All right, thank. And I'll submit the continuance order to the email address you indicated before.
Yes. Yes. You would submit that order to the email address.
And that's July 13 at 1:30.
Right. I apologize. I misspoke. You would send that order, that continuance order to that CC 307 email.
Will do.
I apologize. That's a different
No.
email than before.
I'm just
I
writing notes.
Ms.
I'm just, I have no problem. I'm just writing notes everywhere. Hopefully I can read my writing when I get back to the office.
Now, the covered dwelling affidavit, you email that to the clerk's email, like, if you're filing a complaint or something.
Right.
Okay?
Regular filing, right.
All right. Anything else?
I think I'm good for today. Thank you very much.
All right. Thank you. Good to see you.
Good to see you. Stay safe.
Okay. All right. Let's see. Bottom line, Innovators versus Brinson.
I'm here.
Who's on?
Good morning, Your Honor.
Brinson.
Ted
Okay.
Kaderko for plaintiff. I see April Brinson's here too.
Okay, just a moment, please. What's this up for, Mr. Kaderko?
It's on my motion to reinstate. However, I brought that motion prematurely. I'm looking to enter and continue the motion for till, I don't know, July 15th in the afternoon.
What do you mean you brought it prematurely?
My demand is not proper. So I wouldn't want to reinstate with a bad demand that hadn't termed.
All right, just explain to me what happened in plain English.
Okay. In April, we gave a 5-day and a 10-day. Well, first we went with a 5-day, then we figured that was wrong. Then we hit them with a 10-day. But there was, Section 8 was there at that time. So that 10-day would have to be a 30-day. And now that Section 8 is no longer in the picture,
Just hang
I've
on.
got to,
All right, just hang on. We got to slow down a minute, okay? Please.
okay.
So it was within the Federal CARES Act period,
Is when the 10-day was given, yes.
so it had to be a 30-day.
That's my understanding.
So then what happened? We got to go step by step. So then what's the next thing that happened?
Then we tried to get into court to reinstate the matter. And now that I've filed the motion to reinstate, I see that that 10 day is no good. So I've got to serve a new 10-day because Section 8 is no longer in the picture.
What do you mean they're no longer in the picture? She doesn't have Section 8 anymore?
Been terminated from Section 8.
All right, just a moment. What, did the case get dismissed or did you voluntarily dismiss?
I voluntarily dismissed because my original 5-day was bad.
Mhm.
Okay. Hang on a minute.
Can I say something?
Yes, but hang on just a minute, ma'am. Let
Okay.
me just find out where we are procedurally. All right, just a moment. Does this property, is it backed by a federal mortgage, Mr. Kaderko?
No, it is not.
All right. It's not a federally backed mortgage, right?
That is correct.
When was she discharged from Section 8? Do you know?
Yes, last month for Section 8 would have been April.
All right, just a moment. Hang on a minute.
Sure.
The Federal CARES Act was enacted March 27th. So she was under Section 8 when the case was filed, right?
That is correct.
Then you voluntarily dismissed it and now you want to reinstate?
That's correct, but I need to get a valid 10-day before I reinstate. So I'm premature in bringing that motion.
All right, so right now the case is dismissed and you don't have a valid demand, right?
That is that's correct.
So we should just strike it off call you do your valid demand and then come in on a motion to reinstate, right?
I can do that also, Your Honor, yes.
I mean, don't you think that's the way to do it? 'Cause
Well, I was
demand
just,
is a condition precedent to the filing of a lawsuit.
I understand. And that's why I was going to wait till after my 10 days and just kick the thing out to the middle of next month and then present the motion.
Well, I don't want to give you a date because the case is
Okay.
dismissed right now, right?
I can motion it then, if you want to
Yeah.
strike it.
I think that's the cleanest way to do it.
Not a problem.
Where's
Ms.
Ms.
Brinson?
Brinson? Hello,
I'm
Ms.
right here.
Brinson.
I
Did you
just have
want
a
to? No, right now, Ms. Brinson, we're just talking about procedure, okay? We're not
Okay.
talking about the guts of the case, like, you know, I paid rent or I wasn't smoking in the unit or anything like that. We're talking about procedure. So
Mhm.
did you want to say anything or did you have any questions?
Yeah, I do have some questions because with the original, so just so I can clarify to make sure we all on the same page.
The case is currently dismissed.
Okay, so the motion to reinstate is for,
He's going to withdraw that, right, Mr. Kaderko?
That is correct, Your Honor.
All right.
because I know when we originally came to court, they were trying to evict me for non-payment of rent.
Right, but
We
that's
can't
all,
do
that's
that.
all in the past. We don't need to go back to that.
No, I'm asking the questions because the information that they sent over to housing is incorrect, which jeopardized my voucher through housing.
All right, well, that's
Because it was-
not in front of me right now. What you may want to do is either contact Prairie State or contact an attorney if you think the landlord did something inappropriate to get you kicked off housing, okay? But that case is not in front of me,
Okay,
all right? So either go to Prairie State or contact an attorney. But all we're doing right now is Mr. Kaderko has dismissed the case, and he said he's going to give you a new 10-day notice, or he has, and he's waiting for it to run out, and then he'll come in to ask to reinstate the case. So nothing's going to happen until that 10-day notice period expires, okay?
okay. So with the case being dismissed, and it was dismissed because of the eviction before, how do I get paperwork to prove that?
Well, everything's in the court file. You can go to the clerk of the court's office in the basement of the courthouse and get copies of the entire file if you wish.
Okay, are they still open down there?
Oh, yeah,
Okay.
you gotta wear a mask, right?
That's fine. I just didn't know if they were open or how that worked.
They are. They're open from 8:30 a.m. till, what is it, 5? Till 5 p.m., Monday through Friday.
Okay.
But you have to wear a mask, okay?
Yes, sir.
And bring your case number.
Okay.
All right, so Mr. Kaderko, you're gonna prepare the appropriate order?
Yes, I will, Your Honor.
So you're gonna withdraw your motion and what, strike it from the call or something?
I'll strike it and withdraw it both if you like.
Yeah, I would, because you have to be really careful when you voluntarily dismiss, because I think you only get one shot to refile, right?
Mm-hmm.
I believe you get the one,
Well, I mean,
chance under
I had a 30-day time period, but the coronavirus stopped me from getting in it.
Okay, all right. So go ahead, submit the order, and then you can mail
Okay.
a copy to Ms. Brinson.
All right, thank you.
Thank you. Okay, Midland Funding versus Waldera. Is anyone here on that? Midland Funding versus Waldera. Let's see. Cone Law Firm.
Yes,
Who said yes? You got,
Your Honor, Sade.
right, you got to raise your hand, Ms. Odigeron. Right? All right. Maybe you did and I didn't see you. I apologize. All right, what are we up for on this one?
What was the case number?
19 SC 5745.
You know what? I apologize, Your Honor. I don't have that up before me. If you can hold on one second, or we can pass that.
Let's see, I have it, that I have your name on it. Hearing on a citation. 5745.
Because I have 5755 up.
That's next.
Um,
I'm looking at a notice saying it's up today, Waldera. Hearing on a citation, looks like a wage garnishment. Hang on a minute. To Amazon. It looks like they say he's an employee, but there's no money that they're paying him.
right. So we would file a non-withholding order.
Hang on a second.
Pull up.
Is it based on a student loan?
I'm sorry, what?
Is this based on a student loan
It
to
is.
judge the debt?
It should be a credit card.
Well, I don't deal with shoulds or might be or coulds. I need, to know what it is. No offense.
No, I understand.
Hang on. Let me look. Looks like a credit card, yes.
You know what? I actually, I looked at this file and we actually handled this on, I believe, the first in front of Judge Brodsky, where we dismissed the citation and we should have entered the non-withholding order on that date. And this date should have been stricken.
Oh, so we can just strike this from the call?
So my apologies if that wasn't in the order, but that was our intention.
All right. Yeah, make sure, guys, when you're continuing cases or sending orders ahead of time, if there are any upcoming court dates, you have to strike those dates. Because we don't know. We're getting a flurry of orders coming in through email, like the day or two before the court hearing or the court date. And we don't know. We can't keep track of all that, right?
Right.
And then your case comes up and I end up DWPing it. So if you're going to send the order ahead of time, make sure you strike an upcoming court date if appropriate. You with me?
Got it.
Guys? Yeah. Ms. Connolly? All right. So we'll just strike that off the call.
Just so you know, there was no order entered on this.
There was no order entered?
Might have been one that you wrote. I remember you wrote on an order that it was too early to sign that order.
There is no order entered in that case, Ms. Odizran.
It should have been sent. I can double check.
The clerk's looking on the computer. And if it was the first, we certainly would have entered it by now. You want to give it another date just so you can figure out what's going on?
Well, I can just submit the order, the non-withholding order again.
Well, now we got to go through it all. All right, so it's not a student loan. Hang on a minute. Hang on a second.
Your Honor, I pulled it up and it looks like it was included in my email that I sent to the CC 307 email address with all my orders from 6/1.
I may not have signed it, and here's a reason why. No. So the return day was April 20th. Okay, the return day on the wage garnishment was April 20th, right?
Right.
So now, according to, you guys got to check through all this stuff, okay? According to the governor's executive order, there's no service of any wage deduction summons between April 14th and June 27th. So you can't send that stuff to me. That's a violation.
Okay,
You
so
want right? The governor's executive order 2020-25.
okay, it was my understanding that after March 8th, or after the order was entered, we couldn't serve any new ones, but the ones that were filed, we could proceed on.
Oh, no service. Oh, hang on a minute. Hang on. Hang on, Ms. Odigeron. I thought it said there's one. Hang on just a minute, okay?
All right.
Oh, no, you're right. I apologize. Sorry about that.
No worries.
You're right. There's no service of a citation. There's a Supreme Court order that says if there's a return day between the period, there's all these different things going on. So I apologize.
Right. And this case is a little bit confusing as well because we filed a citation as well as a wage deduction, but we wanted to just proceed on the wage deduction and enter a non-withholding order.
Okay, so let's see when it was served. So it was delivered on March 20th, which was before that order became effective. Okay, you're right. I'm sorry. All right, so wage deduction. All right, so you want to enter, now hang on, now there's another thing we have to do. I apologize. You have to let the guy know to appear by Zoom.
So
did you give him a Zoom notice, the employee, defendant, did you give him a Zoom notice to appear today by Zoom?
So we were under the impression that the order was entered on the 1st, so we didn't send them a notice for today's date because the order that we sent to be entered on June 1st indicated that today's date was stricken. So
you don't have such an order, Madam Clerk?
It was never entered on print, but I remember we had an order that you wrote a note on that it's too early.
From this case?
I believe it's this one.
And you remembered it?
I think because I remember the law firm.
Oh.
I can call to see if you can check. You should have sent it back. Then.
Well, we don't have an order, so did you make, I don't know. To tell you the truth, all I know is we don't have an order.
Yeah, so it was included in the PDF with all of the other orders from that day.
I don't know. I'm just telling you, we don't have the order. That's in the, it hasn't been entered.
Okay, so I mean, we can send in a new order, we can get a new date, whatever you're on.
Well, why don't we get a new date, okay, and allow the, there's not any money being withheld anyway, so it's no harm, no foul. So why don't we'll pick a new date and we'll for entry of a wage deduction order and give the guy notice to appear by Zoom.
If we can select July 13th.
In the morning or the afternoon?
In the afternoon, if you're on there.
Okay, July 13th in the afternoon. How are we looking at it? All right, that's fine.
Okay.
I'm sorry, but you know, it's been a little chaotic.
Oh, I understand, Your Honor.
So, all right. So July 13th in the afternoon, okay?
Yes.
All right, for entry of a wage deduction summons, make sure the guy gets the appropriate Zoom notice. All right, now we have Unifund versus Harris.
This one was actually up on a third-party citation to discover assets. Our issue here is we haven't received an answer from the employer to let us know from the bank to let us know how much is in the account.
Is it Great Lakes Credit Union?
Yes, that's correct.
They sent the answer directly to us. It says 0.
Okay, so then we can just go ahead and dismiss the citation.
All right, so you'll send an order?
Yes, we'll do.
All right, hang on. Midland Funding versus Carranza.
This case is up for a citation to discover the defendant's assets. I'm not sure if she's present in court.
Carranza? No.
If we can just continue the matter for citation one more time.
All right, hang on a second.
I'm right here.
Oh, she's here.
All right. What's your name, ma'am?
Selena Carranza.
Okay, it doesn't say that on your name. It says LG Stylo 4.
Oh, sorry, that's my phone. I'm not sure I would fix that.
Well, remember I said you click on participants, and then I went through all that in the beginning of the court call. But anyway, you can do that for next time, okay?
Okay.
Make sure your name is correct and your case number, like I mentioned at the beginning of the court call. All right, so you're Selena Carranza?
Yes.
All right, just a minute. Miss Odizeron, is this based on a student loan?
No, it is not.
All right, just a moment. All right, just a moment, folks. Okay, it was served before the governor's order became effective. Hang on. All right, she's here. All right, ma'am. Do you wish to take her citation, Miss Odizeron?
Yes, I was going to ask, Your Honor, if there's a way for us to go into a breakout room.
Yes. Now, Miss Carranza, do you have a copy of the citation in front of you?
I'm not in front of me. No, I do not.
You're garbled. What, do you have a copy of the citation in front of you?
No, I do not.
You don't?
No, not in front of me.
All right. So here, next time you come to court, you might want to get on what are you on, a phone?
Yeah, it's on a phone.
All right. You may want to see if you can get on a friend's laptop or computer because you're very garbled. Okay. That happens sometimes.
Okay. Okay.
All right. How much is the judgment?
The judgment was for $6,913.40 plus court costs.
All right. I'll put you guys in a breakout room and let you take her citation. Now, just so you know, Mr. Odizeron, there's an Illinois Supreme Court order that says if there's a third-party citation on a bank, the $4,000 wild card exemption's automatically applied.
Right.
Right? I mean, it doesn't seem to make sense that, well, you're not here for a turnover. You're just here to gather information.
Yep, that's correct.
All right, that's fine. All right, so Ms. Carranza, in a minute, you're going to get an invitation to join a breakout room. There might be something that pops up on your phone, okay? So click accept right away. Otherwise, it's going to go away. So click accept right away. Can you raise your right hand? Do you swear to tell the truth?
Yes.
All right, you can put your hand down. Miss Odizeron is going to ask you a series of questions, and then you guys are going to come back into the main room, okay? There should be a button in the breakout room to say, rejoin meeting or something, okay? Do not leave the meeting. Don't click that button or you'll leave this meeting, all right? Or not meeting, but hearing. So do not click leave the meeting. It'll be, rejoin meeting or leave breakout room. You got it? All right, so hang on. how did I put Mr. Montgomery in breakout room 1? That's not, I didn't mean to do that. Hang on. Breakout room 2, assign. There's Miss Carranza, and there's Miss, okay, hang on. Mr. Montgomery, you may get put into a breakout room. If you do, leave it and come back in. I don't know how you got put into breakout room 1, okay? All right. All right, did you get an invitation to join? There, they left. Did you get an invitation, Mr. Montgomery?
I did, Your Honor, and I pushed later.
Okay.
Give me a choice of later.
All right, very good. Thank you. All right, so they're in a breakout room and they're talking.
Don't forget about them.
Huh?
Don't forget about them.
Okay, I won't forget about them, I hope. Breakout room. Okay. We're getting to be old pros, Madam Clerk, this stuff. All right. There's that. Okay, now we have, there's not too many cases left, folks. Phoenix Capital versus Judah. Is anyone here on that?
Tyler Spillman on behalf of plaintiff.
Okay, what are we doing on this one?
We do not have service on this matter. We're probably going to need a 2031 motion. I don't have one at present, so we'd just like to strike it off call if we could.
Okay, can we do that? So ordered. We'll just strike it off the call.
Do you need a written order for that?
No.
All right, that is
Thank
it for
you.
me then. Thank you, Judge.
You're welcome. Caddis Funding versus Brown. Is anyone here on that?
Yes, good afternoon, Your Honor. Rex,
Hello.
is that-
Can you either get closer to your microphone or turn it up, please?
Yes, Your Honor. Can you hear me better now?
No. I can barely hear you.
Seki for plaintiff?
All right. Yeah, belt it out, okay?
Yes, Your
What are
Honor.
we doing on this one?
Your Honor, we'd like to strike this off call. We mailed an order on a couple days ago. Strike the employer citation off call. We do not have service. We just issue an alias citation at a later date.
Okay, now you're coming in better. What, were you turning it up or something? All right. So you submitted an order a couple days ago?
On the 8th of June.
All right, so in the future, make sure you strike today's date, okay? All right.
Yes.
All right, we'll strike this off call, Madam Clerk. Yeah, in the future, counsel, make sure you strike the upcoming court date, okay? All right, Benevito versus Warren. Is anyone here on that? Yeah. Saragusa. All right, so it's up for DWP, so do a DWP order. Okay, not a notice, but an order. Thank you. Progressive versus Itch. Hello, Ms. Connolly.
Good afternoon, Your Honor.
Okay, what are we doing on this one?
I'm here on behalf of plaintiff.
Hang on a minute. Why is this in, hang on a second. What kind of case is this?
It's a subrogation case resulting from an auto collision.
Why does it have an LM designation?
It is over 10,000, so I'm not quite sure about the jurisdictional limits
Should be AR.
in Lake County. I'm sorry?
Here's what I'm thinking happened. On the civil cover sheet, someone probably checked the wrong box. Oh, no. You did. I don't know why it got designated LM. Deutschman, is that Jeff Deutschman?
It is.
Oh. Okay.
On this one, Your Honor, there is also a personal injury case in Lake County. So this has been transferred from Cook County to Lake, and I believe it needs to be consolidated. It just has not been before the court on that issue.
Well, here's the thing. I do evictions here and collections. So this is in the wrong courtroom, right?
I did seem to notice that during this.
Let's see. So we need to transfer it. How much are you seeking?
Just over 10,000.
All right, so it'd be an ARB case, an arbitration case.
Okay.
And you said there's another case that should be consolidated with?
A personal injury case, yes.
Is that in law division
That is,
or is it an arbitration?
that's also an arbitration.
All right. Do you know the case number?
I do. It is 19 AR 931.
931. You see that? What's that up for next?
117 for motion to continue arbitration.
Okay, so that's up June 17th, right?
Correct.
All right, so hang on a second. Do we have a reassignment order? I wonder if I can just. Hang on, ma'am.
Okay.
I'll be right back, okay, folks?
Okay.
Okay, Ms. Connolly. So your other case is assigned to Judge Rochford, who's our arbitration judge.
Okay.
So this one would be reassigned to her anyway, okay? And then you can ask her to consolidate them. You could bring a motion to consolidate. Okay?
Okay.
So I'll set this for the same date so that you don't have to keep coming back over and over.
Okay. And did you want me to create an order transferring it to, you said it was Judge?
I'm doing it here.
Okay.
I think I have to do it. I don't think you can do it.
Sure.
Tell Mr. Deutschman I said hello. He used to work at Arnold and Cadgen.
I'll let him know you said hi.
Way back he was there like in the 90s.
Oh, wow.
And he
So
left just before I got there, but his reputation preceded him.
I'm sure it did.
In a good way.
Of course. And then will I receive a copy of that order through the court or?
Yep.
Okay.
Yep. Right, Madam Clerk, you're going to mail it out to her? Okay, I'll put in here the clerks to mail it out. All right, just a minute. All right, so it's going to go to Judge Rochford. What courtroom is she in?
207.
207?
Oh no, I'm sorry, 201, but the other case is being heard in 207.
How can that be? Oh, that's Judge Haxel, right? So the other case isn't being heard by Judge Rochford?
The assigned Judge Rochford, but
In 207?
so previously it's been heard in 201, and the next coming date is in 207.
It's in 207? All right. I'll put Rochford / Haxel.
Okay. I'll call it the station.
Yeah. And it's set for June 17th?
Yes, at 1:30.
June 17th at 1:30.
Okay.
And that's in courtroom 207, which is Judge Haxel.
Okay,
Okay?
sounds good.
All right, hang on. Clerk to mail. Now, what you may want to do, counsel, is send a letter to the defendant or the defendant's attorney saying this case is going to be heard on that date and time in 207, and send
Okay.
them a Zoom notice.
Okay, I can do that.
Because if you go and the judge is going to say they didn't know to be here by Zoom, he's going to give you another date, okay?
Okay,
To all parties. Mail a copy of this order to all parties. Okay, so can you get this out in the mail today?
Yes, I can email it to her.
Yeah, but what about the defendant?
I do have the defendant's email address, or the defendant's attorney's email address.
Okay. All right, we'll get it to him today because it's up next week, okay? All right, that should take care of that one. All right.
Okay,
Thank you.
thank you. Have a good day.
You too.
Thanks.
All right, we good? Okay. Bulk versus the beauty spot. Are you guys back from your citation?
Yes.
Okay, so what'd you do? You just clicked rejoin the main meeting?
Yeah.
Oh, okay, that worked out. So what are we gonna do?
So I took, I got some information from Ms. Carranza, so we're just gonna dismiss the citation.
Okay, can you send me an order to that effect?
Will do.
Okay, thank you, folks.
Thank you, Judge.
Thank you.
Okay, bulk versus the beauty spot. Hang on. Mitchell Chabin. All right, you want to send a, hang on, it's a motion to vacate. Let's see what's going on. All right, you want to strike it off the call, please? All right. Cambridge Courts versus Shea. All right, you want to send a DWP notice, please? All right. Patel versus Gumkowski.
Yes, Your Honor.
Okay. What are we doing on that one, Mr. DeSantis?
Your Honor, we actually were just retained on this one, and it
Can you
looks
turn
like,
up your mic?
I'm sorry, can you hear me now, Your Honor?
Yes.
We were just retained in this matter, and it looks like in the last order, plaintiff was granted leave to file an amended complaint. I don't believe that was done.
All right. So
we're
I'll
just
send,
asking-
hang on a minute. Plaintiff granted leave to file. All right, so I'll send a DWP notice, okay? Are you the defendant?
No, we're the plaintiff. I'm sorry.
Oh. Well, then I'll dismiss it. All right, so what, do you need more time to do an amended complaint?
Yeah, we need leave to file our appearance and file an amended complaint and then just come back.
Right. It looks like there's a corporate party plaintiff or something.
Correct.
All right, so when do you want to come back?
We can come back on a status the earliest date available.
That's in the middle of July. How's July 13th in the afternoon looking, Madam Clerk? Can you do July 13th in the afternoon?
July 13th will work, Your Honor.
Okay, hang on. Let's see if it works for us. Okay, July 13th in the afternoon.
All right, sounds I'll set up for a status for that date.
Right. Send in an order and make sure you let the other side know, with the Zoom notice.
I do believe the other side is here. I see someone else logged on with the same case number.
Who's that? Matt Gumkowski.
I'm sorry my video isn't working, but I am here. I am on the audio.
All right, well, you got to speak up and say, I'm here, okay?
Okay, I'm sorry.
All right.
It's the first time I've ever done this. I apologize.
Oh, no problem. We're all new at this. Okay, so, sir, we're going to call. Are you available July 13th at 1:30 via Zoom?
Yes. Yeah, this should be fine.
All right, so let's get on it, Mr. DeSantis, so we get that amended complaint in order, okay?
I will get that filed.
All right, he's gonna file an amended complaint, sir, okay?
Yes, Your Honor.
Because Patel apparently doesn't own the property. It's owned by a corporation, so. Okay?
Sounds good. Thank you, Your Honor.
All right, you'll get notice to come back. Make sure you come back.
Absolutely.
All right, thank you.
Thank you.
Okay. So still send the notice, Mr. DeSantis, since you're doing the order.
I will.
Okay. All right. People, State's Attorney of Lake County versus Collier. No one's here on this, huh? CF. Why do I have a CF? Why do I have a felony case? Oh, really? Well, let's strike it from the call. Status of bankruptcy. Oh, Arnold Scott Harris. All right, you want to strike it from the call? All right. Okay, oops, sorry. Okay, now we have Independent Bank versus Apple Sheridan. Everyone can unmute themselves, and I'm just going to go around the horn. Whose phone number with the last 4 digits, 1449? Who's that? Who's on the phone with the last 4 digits of 1449? All right, anyway. Okay, so. Okay, so Apple Independent Bank versus Apple Sheridan. Mr. Montgomery, who do you represent?
I represent Ron March and Ron March and Associates, Inc., Your Honor.
Okay, Mr. Tim, who do you represent? Oh, hang on a minute. We have a court reporter. Mr. Montgomery, can you speak slowly and loudly and make a record of, well, who's the plaintiff? Who represents the plaintiff?
I do, Your Honor.
All right, Mr. Hendrickson, Matthew Hendrickson, you represent the plaintiff?
Yes.
And this is Independent Bank versus Apple Sheridan, 11 MR 37. All right. Can you make a record, Mr. Hendrickson, and say why we're here? And you have to speak slowly because I think there's what, 6 or 7 motions that are up. So
that's
are
correct,
you
Your
prepared
Honor.
to do that?
Yes, I can list off the motions.
All right, nice and loud. Your voice is a little soft.
So for the record, we are up before the courts on Plaintiff's motion for turnover of funds from third parties and rule to show cause against Ron March. Second, plaintiff's motion for rule against Maureen and Roberta. Let's see. Third, Independent Bank's motion for leave to file combined overlength brief with reply in support of motion for turnover. Independent Bank's motion to avoid fraudulent transfers to third parties. I believe we also have Ron March and Associates motion to compel release of Fifth Third Bank accounts. Independent Bank's motion to clarify or vacate the February 18th, 2020 order and to deem its response to the motion to dismiss as its response to both the motion to dismiss and motion to compel.
Okay, keep it a little bit slower. Go ahead. Anything else?
I think that's it. I think defendants also have a motion for extension of time.
Right. Okay. So you represent the plaintiff, right, Mr. Hendrickson?
Yes.
Okay. Mr. Tim, who do you represent?
I basically represent myself. I received the citation
Against you
for Tim,
personally?
against Tim and Garfinkel.
Is Tim and Garfinkel a corporation?
It's an LLC.
All right. So you need an attorney to represent you. You can't represent yourself. Okay.
Okay. I am an attorney. So.
Oh,
It's okay.
Tim
and Garfinkel is a law firm. But I have not filed an appearance in this case.
Okay.
So
we'll get to that in just a second. Okay.
Mm-hmm.
All right. So let me get one thing out of the way, then we'll get to the merits. Who represents Independent Bank?
I do, Your Honor.
Okay, so I received as a courtesy copy, a physical courtesy copy, plaintiff's motion for turnover of funds in possession of certain third parties and for a rule to show cause against Ronald March. And this is what it looks like. And it's about, I don't know, 3 inches thick, maybe 2.5 inches thick, with exhibits A through N, as in Nancy. And the only thing holding this voluminous document together is a big clamp clip. So one fall down the stairs and this is everywhere. Are you with me?
I understand, Your Honor.
You have to bind it, counsel. You're killing me.
And just for the record, it's been a little difficult working remotely. And because we're working remotely, I instructed our mailroom to use a binding comb, which is in Michigan, and apparently they didn't.
All right, because you knew I was going to say that, didn't you?
I know how much you love tabs and you love binding combs, and I agree 100% because it makes it so much easier on cases like this when you get a lot of exhibits.
All right, so I got that out of the way.
Thank you.
Now, I think it makes sense to first do the motion for extension of time, because if that is granted, then we don't have to hear all these other motions at this point, right? Because I'd rather hear them all together than just piecemeal, because there's a lot going on in this case. Okay. All right. So let's hear the motion for extension of time first. Okay.
All right. Thank you, Judge. That's our motion. That's Ron Marsh's motion, based on the executive orders that have been in place and as amended in Illinois. Stay-at-home orders was extended through May 29th. The Secretary of State's office was shut down for business services. It's only recently come back to partial operational status. We are seeking additional time for corporate filings, corporate accounting, corporate governance business to supplement our exhibits D and E to our response to the motion for turnover of funds and for rule to show cause against March.
So
Which
why do you need that? Why do you need the Secretary of State's corporate office to be open?
this is an attack on a separate corporation. It's an attack on 160 Plainfield LLC. It's not a defendant in this case. It stands on its own. It was just recently reinstated. There's a charging order that's in a place for Ron Marsh and Associate Inc.'s distributional share. So we need to determine what that distributional share is and report that to the court so that if there is any distribution, that be turned over. Right now, we've filed a response. The exhibits D and E were not complete because we're waiting for the Secretary of State's certificate of good standing to be issued. The whole Secretary of State's office was shut down. They wouldn't answer the phone. They wouldn't receive mail. In order to reinstate, we had to send in a certified check. We could not do that online. It had to be paper, mailed by paper with that check.
All right. So how much time, if it's granted, how much time are you looking for?
A reasonable amount of time. We also have
that doesn't.
Okay, we asked for July 7th. We asked for July 7th.
All right. Okay. Response?
Your Honor, I was copied on an email that I think was sent to your clerk on Monday that contained a certificate of good standing. So I was under the impression that they had already received the certificate of good standing they were looking for. Is that not the case?
Well, he may have gotten it, but then he has to then draft a response or part of a response based on that.
Well, and I think they already raised all those arguments in their response, Your Honor, and we addressed this in reply. I think, quite frankly, it's irrelevant whether or not the LLC is reinstated. The LLC was dissolved in 2007. They haven't stated any reason why they couldn't reinstate it at any time since 2007, and why they waited until now. And I don't think it's even relevant anyway, because, and this is all set forth in our briefs, once they made these payments, once 160 LLC made these payments to the third parties, they became distributions for the benefit of our judgment debtor, RMA LLC. Once they became distributions, it doesn't matter if they reinstate at this point. The bell's already been rung, the money's been paid out. It's a constructive distribution, and therefore the bank's citation lien and the charging order he mentioned attached to that lien, and they can't unattach.
Well, let's do this, Mr. Hendrickson. If I deny Mr. Montgomery's motion, right? So let's say you're sitting in Elgin, you've just been promoted, and you're in Elgin, and you have an attorney on a very involved case, right? And there's, I don't know, 5 or 6 motions pending. And we're kind of following the money in this case. It's taken a little bit of a torturous trail, right, that we have to unravel and peel back. And then one of the parties asks for a continuance to file a response brief or part of a response brief because of COVID and because the Secretary of State's office has been closed down, and the trial court says, no, I'm not doing that. And then if a ruling comes down against that party, it's got, I think personally, it has reversible error written all over it. And then we're going to all come back and spend a bunch of more money when it gets remanded.
And maybe I'm misunderstanding his request. I thought they were just waiting to get the certificate of good standing, which I think they got on Monday. I didn't see a request in there to file a supplemental brief. I think they just want to insert that document into the record, which could be done now.
Okay, I may have misspoke, all right? But I'm going to grant the extension of time. I think it would be too draconian to not do that. All righty. And like you said, if the bell has already been rung and the damage has been done, it's not going to hurt to give them a little extra time to, make sure that their brief is complete and take away any type of appealable issue. Okay.
Okay, can we include in today's order that all the funds which are the subject of the motion to turn over, or the subject of the motion to turn over, shall remain frozen?
Well, you still have a citation in place, right?
Right, but it never hurts to have an additional reminder. It's been so long since we were in front of the court.
We would object to that, Your Honor. His motions speak for themselves as far as turnovers go, but he has not upped his citations at all. So they've actually expired.
What I'll do
There's
is,
no motion for that.
if there's citations in place, I'm going to enter and continue all citations and all pending rules to show cause. I'm just going to enter and continue them all so that the freeze orders remain in place. That's appropriate.
Understood.
Okay, so put that in the order, Mr. Hendrickson. I'll have you do the order, okay? So all citations and freeze orders remain in place.
So, Your Honor, the
And
fifth,
rules,
third,
and rules to show cause remain in place. What else? Now, I'm going to grant Mr. Montgomery's motion for extension of time. And it's an extension of time to do what again, Mr. Montgomery?
to supplement the response to the turnover motion and rule to show cause against March, which response is actually incorporated into the other two motions for.
Hang on, because he's writing all this down, Mr. Montgomery. All right. Do you have that, Mr. Hendrickson?
Yeah.
All right. So then the last thing to do, now you need to get me your whatever you wish to add in here, Mr. Montgomery.
Absolutely, Your Honor. I'll file it and send you courtesy copies.
So can I put in the order that the court will retain the courtesy copies?
Yes.
Okay.
Now, Mr. Montgomery hang on just a second. You already filed a response, right?
Correct.
Okay, hang on a second. So why don't you call it an amended response?
Okay.
So that I can keep it separate, okay? Amended response, and resubmit the whole thing with the additional documents in it. Okay, don't just give me the additional documents, say shove them in this big, thick response you have. Give me an amended response with everything in it. Okay, a physical copy of it.
Okay.
With tabs and it's bound, right?
Yes.
All right. When do you want to get that done by?
I can get that done by the end of the month.
Well, don't you just have to stick in the certificate from the Secretary of State?
And a resolution. I could get it done in 7 days, maybe. Is that fair?
All right, you can do it all right. Let's see, what's today, the 10th? All right, I'll give you that extra time. I'll have it done by June 22nd.
Okay.
That's a week and a couple extra days, okay?
Okay.
So have that filed by June 22nd, then pop it in the mail to me and all opposing counsel. All right, then, let's see. Let's set it for hearing, okay?
Okay.
So the next step is to have a hearing on all these motions, correct?
There's two motions that are presented for presentment today, which we need to respond to.
What are the two motions up today?
Motion to clarify and a motion for filing a very lengthy extended reply by the plaintiff.
All right, I'll grant your motion to file what you're going over the page limit, Mr. Hendrickson.
Yeah, I think we're at 15 pages rather than the usual 7 because we respond to both Mr. Tim and Mr. Montgomery's
That's fine.
response briefs in one brief.
I'll grant your motion to exceed the page limit.
Thank you.
So put that in the order, okay? And then the other motion, Mr. Montgomery's.
The other motion, Your Honor, is we brought a motion to dismiss the citation issued to Fifth Third's 160 Plainfield LLC's bank account, which was granted. And they are moving to clarify that. And every time they come back, they try to put in that citation is continued. It's expired by the length of time. It was initially responded to in November of 2019. And it also was dismissed by Your Honor. So if I have to respond to that, I need to respond to that. I need 28 days to respond to that.
Your Honor, I would object to that. At the last hearing that we were in front of the court continued the citation to the March 11th date, which was the date that was reset because of all the COVID stuff. And actually, as I think it's all irrelevant anyway. I think the proper thing would be for the court to have the hearing on the motion for turnover. And if the issue of whether or not the Fifth Third citation has been dismissed is even relevant, then we can have that fight. But that issue is addressed in their response brief and our reply brief. The motion that we filed was just a formality to have a motion on file that incorporates the arguments in our reply brief.
Okay, hang on just a second, okay? So which bank is the subject of the citation?
Fifth Third, it's you dismissed it as to the 160.
All I need is a name of a bank. It's Fifth Third?
That's correct.
All right. At any time after the citation was issued against Fifth Third, did Fifth Third file an answer to the citation?
Yes, they filed immediately November 8th of 2019, and he never took any action. Okay.
Mr. Montgomery,
All right.
the answer is yes or no?
Yes.
Okay. Do you agree with that, Mr. Hendrickson?
I don't have the exact date in front of me, but that sounds about right, yes.
I don't need a date, but they filed an answer, right?
They did, yes.
Were they holding funds?
They're holding the $22,000, which is the subject of this motion for turnover that is set for hearing today.
Okay, so at any time, it seems that unusual that I would dismiss a citation if a bank is holding money.
Well,
they weren't holding the defendant's money. They're holding money for a third-party corporation.
Well, I think that's the crux of the whole case, really.
And then there was a charging order entered. So that covers whatever amount would be paid to one of the defendants as a member of the LLC, not the account. The account is corporate funds. Those funds were used now, once the case was dismissed, funds were used to reinstate the corporation. The corporation wants to move ahead with its own existence.
Well, there's, again, the crux of the case is who belongs to what corporation, et cetera. There's a main corporation, then there's some subsidiaries and money flowing back and forth between those two entities and some individuals. So like I said before, we have to peel back some of these layers. So I'm not in a position today to release any bank accounts or dismiss any citations. I don't want to do that at this point.
It was already ordered that it was dismissed, and the money was used to pay the Secretary of State.
Well, if it was ordered and if I already ordered it dismissed, then why are we revisiting it today?
I don't know. He didn't take any action on it. And now he wants this motion to clarify or vacate it. So I need 28 days to respond to that motion.
Did I enter just hang on? Did I enter an order dismissing the citation on that bank?
As to the 160 Plainfield LLC account, yes.
All right.
Your Honor, I was hoping we wouldn't have to get into this because, again, I don't think it's relevant to the motion for turnover necessarily, because that deals with who's entitled to the money in that account. Yes, there was an order entered dismissing the citation. However, and this is all laid out in our reply brief, there was a motion to dismiss the citation that Your Honor denied in late January. A week later, defendant filed another motion to dismiss. I responded saying, I'm on a family vacation in California. I can't be at the hearing. Can we do an agreed order? He appeared in court, notwithstanding my request, had the citation dismissed, and then the next day told me, yes, we can do an agreed order. So I don't even want to get into this to the squabble between the two of us, because I don't think it's relevant. I don't think the court wants to hear it.
Well, you just brought it up. So that's not what happened at all. So I don't appreciate that.
Just hang on. We've got a court reporter. All right. All right. Let's do this. Okay. We'll enter a briefing schedule on it, and I'll hear everything all at the same time. But in the meantime, all citations and rules are continued. I'm not reinstating any previously dismissed citations. I'm just saying all current citations and rules are entered and continued. You can brief this issue as to whether the citation on 5/3 was actually released or not. And then we'll have a hearing on all of the motions at the same time.
And respectfully, Honor, we already have. It's in his response brief. I addressed it in the reply, and then just filed a one-page simple motion to reinstate, so that there was a proper motion before the court to give the court the opportunity to rule on the motion if it was even relevant, which I don't think it is. So it's already been fully briefed.
Do you agree with that, Mr. Montgomery?
Not really, Your Honor. I mean, there's so
All
many
right,
briefs
let's
flying
enter
around.
a briefing schedule. Okay. How much money are we talking about here? What's the judgment?
It's it changes the number every time, so
All
it's
right,
hard to
Mr.
say.
Montgomery,
All
let's act. Let's not make snipes at opposing counsel.
Yeah.
What's the judgment amount?
The judgment was around $450,000, and it's accrued
All right.
10% interest since
All right. Well,
since
you guys
2009.
You guys are quickly approaching that in attorney's fees. But anyway, all right. So how much time do you want to respond, Mr. Montgomery? But whose motion to clarify is it?
It's his motion.
All right. So how much time do you want to respond, Mr. Montgomery?
Well, when would a hearing be available for Your Honor on?
It all depends on the briefing schedule.
I would ask for 14 days at the very minimum.
All right. So that's to the 24th. How much time to reply?
7 is fine. Thank you.
That brings us to July 1st. All right, so then you have to get that to me, okay? You're the movement, Mr. Hendrickson, so mail it to me.
I understand.
Physical copies. All right, hang on. So I'll probably get it that week of the next week, since it replies due on Wednesday. Hang on. All right. I'm going to specially set this because this is going to take a while. I'll do it on a Friday because those are my specially set days, okay?
Okay.
Give me one moment. How does August 14th look for you guys?
One day before my birthday. It's okay, though.
Your Honor, I believe I might be out of town that weekend.
Okay.
My wife might have something planned I don't know about.
For your birthday?
Yeah.
Are you planning a surprise birthday party for opposing counsel?
He wants to come. It's probably going to be out of state.
How about the 21st of August? Are you guys available?
That should be fine.
Yeah, that looks better. That looks better.
Yeah, that's fine with me. Could I double check with my wife though about what day she's planning this trip, and we confer and pick between those 2 days?
I'm going to go get my book, Why don't you mute yourself, Mr. Hendrickson? Can you call her?
Yeah, I can get a hold of her.
Yeah, give her a call and ask her, and I'll come back with my book, okay?
All right, I'm sorry. Thank you.
No big deal. All right.
Bye.
Let's all mute ourselves.
Can I ask a question?
Yes, sir.
The
That's Mr. Tim, Madam Court Reporter.
yes. Am I necessary for this? I have a conference call at 3 o'clock that I could take.
Today, right now?
Yeah.
No, you can leave. If you don't have an appearance on file, though, you're not going to get a copy of the order.
That's okay. Will sends them to me.
Okay.
So does Mr. Henriksen's paralegal sends them to me as well.
Okay. Yeah. So it'll be sometime in August. Okay. But you can check the date.
Okay. I appreciate it.
Now, Mr. Tim, if you have anything that you want to present on that date, make sure it's, all ready to go. Okay.
Okay.
All right.
Will do.
All
Yes,
right.
sir.
Thanks.
Thank you. Appreciate
Okay.
it. Bye now.
Madam Court Reporter, do you need anything from us?
No, I'm good, thank you.
Okay. How's it going with the court reporting over Zoom?
It's going.
Yeah.
Not too bad.
Okay.
It's been slow getting back.
Sometimes people get on and they have a really garbled transmission.
Well, luckily for me, like if it's garbled, then it's garbled for everybody. So then they just stop. It's not just me that can't hear them.
Well, that's true.
So how's everything there?
Good. We're getting through it.
Yeah.
It's going a lot smoother than we anticipated, so that's good.
Good. I'm sure it's been a challenge.
Yeah.
All right. I'm sorry, Judge. So I can do the August 14th. I will be out of town August 21st.
Okay. Are you good, Mr. Montgomery, with August 14th?
Liz, can I do, hang on, Judge, I'm gonna call my wife.
Okay, you can mute yourself.
I'm on Zoom, I'm trying to get a court scheduled here. She unfortunately said the 14th. My birthday's the 15th, so we would leave.
20th.
So the 21st would work, but it doesn't work for plaintiffs. So
well, I could go the 28th. I mean, I'm sorry to keep pushing it back, but I need some time to wade through all this stuff.
28th works for me.
Is the 28th okay with you guys?
Yeah, that's fine.
Yes.
Okay. All right. Why don't we do it at 10 a.m. Right? Is that okay with you guys? Because then if it goes long, we have the whole day, right? We'll break for lunch, and we have the whole day.
Yes.
All right. So 10 a.m.
And to clarify, we're talking about oral argument, not an evidentiary hearing, correct?
Right. Oral argument.
Okay. Okay.
Well, do some of these things require an evidentiary hearing?
I don't think they do.
I wouldn't think so.
All right.
There's
well,
already
let's
been
not- let's not
testimony
muddy
and
the
citation.
waters then.
I'm sorry, what?
Let's not muddy the waters then.
Yeah, okay.
All right, so hearing, hang on just a second. Just a moment. 11 MR 37, hearing. All right, just a moment. Okay, anything else before we shut down?
I think that's it.
That's all I have, Your Honor.
Okay, 8:28 at 10 a.m. for hearing. Hearing, just a moment, on all motions. All right. Let me write this down. Okay. Well, everyone, enjoy your time out of town and birthdays and all kinds of fun stuff. All right, August 28th at 10. All right, you're in the book. So make sure, who's doing the order, Mr. Hendrickson?
Well, yeah.
All right, make sure you get it to me as soon as possible today, okay?
I'll work on it right now.
Okay. You may want to send it to Mr. Montgomery first and then submit it, okay?
Yeah, I was planning on it.
Okay, all right. All right, thank you, gentlemen. Thank you, Madam Court Reporter.
Thank you.
Thank you.
Judge, thank you, Matt. Gonna leave now. Here.